All right, we're going to read the sentencing transcript of Jeffrey Weinhaus. I'm starting on April the 23rd, the year 2017. I suspect it might take me a day or two to make it through. It's 63 pages. And on the screen you'll see a picture of Jeffrey Weinhaus and his mailing address, and I pray that you mail him a letter in prison. All right, let's get started. Page 1. State of Missouri versus Jeffrey Weinhaus. Before the Honorable Judge Keith Sutherland, transcript of sentencing hearing taken November the 25th, 2013. Reported by Kim Rockledge, CCR. Rockledge Reporting, LLC, 467 Brookfield Drive, Washington, Missouri, 63090, 636-583-1953, or 314-210-6917. In the Circuit Court of Franklin County, State of Missouri Plaintiff, number 12AB-CR02409-1 versus Jeffrey Weinhaus, Defendant. Sentencing hearing taken at Franklin County Justice Center, 401 East Main Street, Union, in County of Franklin, State of Missouri, on the 8th day of October, 2013, before Kim Rockledge, CCR. Appearances of counsel. For the plaintiff, Mr. Robert Bob Parks, Franklin County Prosecuting Attorney's Office, 20 North Church Street, 2nd floor, Union, Missouri, 63084, 636-583-6370. For the defendant, Mr. Hugh A. Eastwood, H. Eastwood at eastwoodlawst1.com. Law offices of Hugh A. Eastwood, 7777 Bonne Terre, Suite 1603, Clayton, Missouri, 63105, 314-727-3533. Mr. Christopher M. Combs, CombsChris1 at gmail.com. Law offices of Christopher M. Combs, 4542 West Pine Boulevard, St. Louis, Missouri, 63108, 314-578-1465. I don't think I'm going to answer that. Also present, Jeffrey Weinhaus. Judge Sutherland. Judge Sutherland, good morning. Mr. Parks, good morning. Mr. Eastwood, good morning. Mr. Combs, good morning. Judge Sutherland, we have several motions we need to take up before we do anything else. Please be seated. What would you like to take up first? Mr. Eastwood, Your Honor, we have several housekeeping motions related to attaching deposition court cost of the state and the defendant too. Judge Sutherland, comment on that? Mr. Parks, we'd ask the court to accept both. Judge Sutherland, these motions are granted and deposition cost and other costs are ordered taxed as cost. We also have the state's motion to forfeit the pistol. I can't remember what the style of it was. Mr. Parks, state's motion to forfeit the weapon, the 9mm. Mr. Eastwood, I would oppose that, Your Honor. Judge Judy Kropf, who was married to Mr. Weinhaus at the time of the incident at the gas station, has filed an affidavit including a sales receipt. She is the owner of the weapon, and as such, as I read the statute number 1, if the state cannot show that the defendant owned the weapon or that the lawful owner of the weapon consented or gave permission for the defendant to carry the weapon, then the state has not met its burden for forfeiture. If the court is inclined to grant Mr. Parks' motion, nevertheless, I'd ask the court to stay any order pending further process. Mr. Parks, Your Honor, I believe the statute is clear in this matter that if a weapon is used in the commission of a crime, it is to be forfeited to the state. The defendant was married at the time, joint possession between husband and wife of the gun. The gun had been found previously at the home, and I believe the state has met all burdens to have this weapon forfeited to the state. The only thing I would ask is if you do grant the order or the motion, that the order be stayed until the appeals are final. Judge Sutherland, all right. Mr. Eastwood, any comment on that? Mr. Eastwood, no, I simply think that there is evidence in the affidavit and with the sales receipt that the weapon is owned by Miss Kropf alone. So I do think that's an issue. Judge Sutherland, well, I will grant the state's motion to forfeit. It's just the one pistol that Mr. Weinhaus was carrying because this does not apply to the weapons found in the car after the shooting. Mr. Parks, we are not asking for the forfeiture of those weapons at this time, Your Honor. Judge Sutherland, State's motion is granted. However, the forfeiture is ordered stayed pending resolution of any appeal in the case. Well, appeal and any conviction motions as well. We also have another motion for judgment of acquittal. Is that what it was? Mr. Eastwood, yes, Your Honor. There are actually two documents before the court. There's a second motion for judgment of acquittal. There is also a supplemental suggestion of law in support of each of the original, renewed, and second motions for judgment of acquittal. Judge Sutherland, right. Mr. Eastwood, first off, there are two issues before the court. Number one, whether the state produced sufficient evidence of the defendant's intent to attempt to assault Sergeant Folsom, and I believe as a matter of law that the state has not done that. Judge Limbaugh, writing for the Missouri Supreme Court on bank, instructs us that merely pulling a gun out is not enough to show attempt. At most, it can show negligence, even great or extreme negligence, but it is not a substantial step towards the assault, and the case law reflects that. Here, the disputed evidence, if the jury believed the trooper's testimony that the defendant did in fact withdraw the gun and say, "You're going to have to shoot me, man," which obviously was hotly disputed at trial, if the jury believed that, nevertheless, that does not show a substantial step towards assault in the first degree. I think at best it makes out, at best, third-degree assault, which would be put to Sergeant Folsom in a reasonable apprehension of harm. Obviously, a very different offense. A Class A misdemeanor. And if you look at the case law on attempt, where the courts have upheld the attempt, is not just pulling out a weapon, but actually pointing it at the person, putting it against their head, saying, "I'm going to kill you," slashing the victim with a knife, and then in fact not really injuring them, just drawing a bit of blood or something like that. But that's enough to show an attempt to cause serious physical injury. Here, the disputed evidence showed only that the defendant pulled out the gun at best. He did not point it at the trooper. He did not say anything like, "I'm going to kill you, man," and therefore I believe as a matter of law, the state just has not met its evidentiary burden for first-degree assault. The second issue, and we've also argued that there are, in order to preserve the argument, that armed criminal action is barred by double jeopardy. And I think that's important, by the way, because going back to the first issue, if you look at the verdict director, the instruction was that the defendant attempted to cause serious physical injury to Sergeant Folsom to trying to draw a weapon to shoot Sergeant Folsom. I believe as a matter of law, that is just not first-degree assault or attempted assault. Turning to the drugs, the evidence showed that the defendant lived in his home with his then wife and teenage son. The 1.5 tablets of morphine, that is the felony drug conviction, were found in the basement Camel brand snuff box. It was a common area of the house and adjacent to the teenage boy's bedroom, and I think that if you look at the cases where the Court of Appeals has overturned constructive possession, Judge Sutherland, I have one of those. Mr. Eastwood, sure, the facts are just not there. I mean, the court has overturned for a lady where she knew of meth being in a kitchen icebox in the fridge, and she even told the police that, and even that did not indicate sufficient constructive control since the kitchen was a common area of the house. Similarly, the court has overturned constructive possession where they found a duffel bag with marijuana on it in the garage of a jointly controlled premises. Here I think the evidence shows that the basement was a common area of the house. We all saw the YouTube video. Of course we know the defendant at some point in the time had been in that basement, but there was no evidence on the day of the arrest or not the arrest, the visit to his home by the troopers, and the defendant had even been in the basement, and therefore I would ask that the court acquit Mr. Weinhaus on the felony drug possession. The marijuana is a little bit different. Sergeant Folsom did say that he smelled marijuana on the defendant's person, but there was no marijuana on his person, and again, the drug, the marijuana, was found in the basement, and for that reason I do not think that they have proved up constructive possession. After all, hypothetically, the marijuana could have belonged to someone else and the defendant had merely smoked it, and still that would not show constructive possession. So for those reasons, we ask the court to enter a judgment of acquittal on each of the charges. Judge Sutherland, Mr. Parks. Mr. Parks. Yes, taking up the marijuana and the drugs first. The drugs, the morphine, and everything we found in a container in the defendant's personally controlled area his command center, or what he told the officers was his command center, and where you saw the video, he made all his videos and his podcasts from. These were items that were found in the drawers in the desk that he used, showing that they were items that were found. As to the marijuana, again, as the defendant's attorney pointed out, when the whole reason for the search was the smell of marijuana coming from the house and from the odor of marijuana on the defendant's person. This is the probable cause that they used to get the search warrant. There was marijuana found in the command center with the other items. There was also a large bag found on a shelf right outside the door. The defendant presented no evidence that there was anyone else that had access to that area. This is not a common area. These are all the items. These are the items, or this is the area that the man cave, the command center, the area where the defendant had primary control over all the items in that area. The state feels that it has more than met its burden on these. As to the assault, first, Your Honor, the testimony was that the defendant was staring down Sergeant Folsom, that he went for his gun and he was going to shoot Sergeant Folsom. Corporal Mertens testified that he thought the defendant was going to shoot at Sergeant Folsom. That's why the officers fired. You do not have to wait until you're shot at to have an attempted assault first of a law enforcement officer. And the state again feels that it has more than met its burden to show an assault first on Sergeant Folsom. Judge Sutherland. Mr. Eastwood, additional argument? Mr. Eastwood. Yes, Your Honor. On the drugs, previously I think the issue of whether or not the defendant is the primary user of that basement space is insufficient to show exclusive control. And that's really the test here. There was also evidence that the 19-year-old teenage son's bedroom was adjacent to that space. Common sense and experience tells us that the basements are typically communal areas of the house. And I think there was enough evidence of that the basement was not under the defendant's exclusive control. And we know from common sense and experience that family members share computer equipment. This was not a wealthy family, it was a family computer, and so for that reason I think the state has not met its burden. Turning to the more serious crime, I agree with Mr. Parks in the sense that we heard plenty of testimony about trooper training, and that's not the issue that's before the court. The issue is not whether or not Sergeant Folsom was justified in shooting the defendant. That's an issue for another day. The issue is, what did the defendant do? If you believe, and the jury apparently did, that the defendant pulled a gun out, didn't point it at anyone, didn't say he was going to hurt anyone, he said, "You're going to have to shoot me, man." That's not a threat. That puts Sergeant Folsom at best in apprehension or immediate let me read that again. That puts Sergeant Folsom at best in apprehension of immediate physical injury. That's third-degree assault. It's a very different crime. Here the issue is whether the defendant attempted to kill or knowingly caused or attempted to cause serious physical injury. And he never got that far. He never pointed it at anyone. He never threatened anyone. So for that reason, I think that the state, at best, may have proved up third-degree assault. That's a different crime, different elements. But it did not prove first degree. Thank you. Judge Sutherland. Well, the motion is denied. Any other motions to take up prior to sentencing? Mr. Eastwood. Yes, Your Honor, we have a motion for a new trial. Judge Sutherland. I'm sorry, yeah, that's the primary reason we set this. Go ahead. Mr. Eastwood. Okay, I think from the minute that Mr. Parks showed that YouTube video and we all saw it, and it was pretty extreme speech, First Amendment speech, First Amendment protected but pretty extreme speech, I think from the moment that the jury saw that video, the defendant could not get a fair trial. The state failed in its burden of proving up the judicial tampering charge, and for that reason the court acquitted Mr. Weinhaus at the end of the state's evidence. Nevertheless, we can never unring that bell. Since the charges were not severed, the defendant could not get a fair trial on the issues before the jury as to what went on at the gas station, because they had seen him in a video a month before talking about blasting judges. These motherfucking judges. I want to blast them out of there. And talking about other people that he believed needed to be removed from office, potentially by violent means. And so what the jury did is think that the defendant was a dangerous man, and acting as a kind of roving commission almost decided that he went to that gas station with bad intent, even though there was no evidence to show separate from this video that the defendant was any more dangerous than any other person on the street. And because of that, I believe on that issue alone merits a new trial. There are several other issues that There were several offers of proof made. During the defendant's impeachment of Sergeant Folsom's testimony, the defendant made an offer of proof on a letter from Franklin County Sheriff to the defendant. The sheriff was present in the courtroom at the time, and that letter would help impeach Sergeant Folsom's inconsistent testimony as to whether or not he notified the Franklin County Sheriff pursuant to the statutory requirements of RSMO 43.200. Sergeant Folsom's credibility was perhaps the most disputed issue in this case. Both sides spent a lot of time going over the trooper testimony, particularly Sergeant Folsom's testimony, because he was the shooter and he was the one with the direct view of the defendant. And therefore, for that reason as well, because the defendant was not allowed sufficiently to impeach Sergeant Folsom's testimony, a new trial should be granted. And indeed, at trial, Sergeant Folsom made up wholly new excuses for his failure to contact the sheriff. He said he had bad cell phone reception near the defendant's house. That was something entirely new. It wasn't in the police report, wasn't in his depot. It was just a new thing. The defendant also made an offer of proof as to his wounds and the location. The entry and exit angle of the wounds was necessary because that also went to Sergeant Folsom's credibility, particularly as to his testimony as to where he shot the defendant and at what angle. One of the issues in the case was whether or not the defendant was getting down on the ground, and of course shooting a person at an angle as they're going down will be quite apparent from the entry and exit wounds. There's no Fifth Amendment waiver issue with a defendant showing his wounds. It's not testimony, and it's not testimonial in nature in any way. It's like a lineup, DNA fingerprints, and for that reason a new trial should be granted. Hwy Weinhaus text message. Sergeant Smith, the investigating trooper into the shooting, had evidence of a text between Hwy Weinhaus, who is the defendant's son, and Mr. Weinhaus's father concerning a weed plant. Sergeant Smith never passed that information on, but the text message goes to the issue of the defendant's guilt on the possession of marijuana. A reasonable jury can infer that based on the text message that the marijuana belonged to the defendant's son. The weapons in the Subaru after the defendant was shot at the scene and the scene was secured and the defendant was cuffed and airlifted to St. John's Mercy, the defendant's wife's Subaru, which was the vehicle that Mr. Weinhaus drove to the gas station that day, that car was inventoried. And during the inventory, the troopers found additional firearms, including a rifle and a handgun. Critically, Sergeant Folsom and Corporal Mertens testified that they had no idea those firearms were in the car during the altercation between Mr. Weinhaus and the troopers. And that had nothing to do with any crime committed, and therefore by permitting that evidence to be admitted over a timely objection, the state was allowed to depict the defendant as coming to the gas station loaded for bear. I think that was Mr. Parks's words, and I think that was improper and therefore had no probative value, but it was highly prejudicial. Again, for that reason, a new trial should be issued. Finally, there was a freeze-frame demonstrative evidence from the wristwatch video. I used it throughout, I think, the state's case and also perhaps in the defendant's case. That demonstrative evidence from the wristwatch video, the video was evidenced properly. Those still frames were used by me without objection through the state's case. As such, when an exhibit is not formally offered or received into evidence but is published to the jury, it is treated by both the prosecution and defense as if it had been received into evidence and is never objected to. And the exhibit is effectively in evidence for all purposes as if it had been formally offered and received by the court. The reason this is important is because during the deliberations, the jury asked to see the video and asked to see the freeze frames, and it went to this critical issue of what the defendant's left hand was doing in the moment before he was shot. They did get to see the video, and those freeze frames would aid the jury because it shows the defendant's hand going back, and the video screen shows the gas station sign in the background, and then moments later the shots rang out. It does suggest that at least the defendant's left hand was in the air. That's a critical issue. That was the issue in this case. What were Mr. Weinhaus's hands doing moments before Sergeant Folsom shot him? And so for those reasons, I ask the court to grant a new trial. Thank you. Judge Sutherland. Mr. Parks, Your Honor, I believe all this has already been covered at the trial and that the court has already ruled. I would like to make a few comments, though, on issue 7 on the freeze frame. Your Honor, the court has complete discretion on what it sends back to the jury. At this time, the defendant did not object when the state raised the issue that these freeze frames had never been put into evidence, and this was after the closing arguments, when the defendant had already had a chance to argue this and everything to the jury. So whether or not they went back to the jury, I believe that is in the complete discretion of the court, and I would ask that the court to deny defendant's motion for a new trial. Judge Sutherland: well, with regard to the freeze frame pictures, of course I did not allow them to be sent back to the jury room because they had not been introduced into evidence. The video itself from the wristwatch video was not obviously sent back to the jury, as we discussed at the time. The jury was brought into the courtroom and shown the video again, and I believe, and I don't want to swear to it, but I believe I asked them if they wanted any of that done, video shown in slow motion or freeze frame by frame, and they did not. So that didn't seem to be such a big issue with the jury. In any event, all these issues were argued previously, during and after the trial, or at the conclusion of the trial. The motion for a new trial is denied. Is there anything else we need to take up prior to sentencing? Yeah, well, I've got something to say. Mr. Weinhaus. Yeah, well, I've got something to say. Judge Sutherland, you'll have a chance momentarily, Mr. Weinhaus. Mr. Parks, not for the state, Your Honor. Mr. Eastwood, not at this time, Your Honor. Judge Sutherland, I assume based on the brief conversation we had prior to coming into the courtroom, you both got a copy of the sentencing assessment report. Mr. Parks, the state does, Your Honor. Mr. Eastwood, yes, Your Honor. Judge Sutherland. Mr. Parks, any comment as to sentencing? Mr. Parks, on the SAR? Judge Sutherland, on sentencing, anything? Mr. Parks, yes, Your Honor. The state believes. Okay, I'm going to pause right there on page 21, and I'll pick this up with page 21 at some point in the future. All right, we're going to pick up with page 21 and try to make it to page 40, and we'll do this in 3 stages. All right, Mr. Parks. Yes, Your Honor, the state believes that the defendant has been fairly tried and found guilty by a jury of 4 counts. The jury has recommended a jail sentence and a jail sentence on the misdemeanor marijuana and a 2-year sentence on the morphine. State would ask that the court follow the recommendation of the court. As Sergeant Folsom said in his statement to the jury, none of this would have happened if the defendant would have just gotten down on the ground. We wouldn't be here facing it, but the defendant, coming armed to this confrontation, decided at that point that he was not going to go quietly, that he was going to have it out with Sergeant Folsom. And if the court remembers the testimony of Corporal Mertens, he said they were locked eye to eye. He was ready to shoot Sergeant Folsom if Sergeant Folsom would not have shot him first. Under those circumstances, Your Honor, the state would ask that the court follow the recommendation of the jury and to run all sentences consecutively. Judge Sutherland. Mr. Eastwood. Mr. Eastwood, Your Honor, as the court is aware, the defendant has been incarcerated in the county jail for over a year. There are 4 charges before the four convictions before the court. A Class A misdemeanor and 3 felonies: possession of a controlled substance, assault on a law enforcement, and armed criminal action. The court heard testimony during the sentencing phase that the defendant has never been the same since he was shot. He was in St. John's Mercy for a couple of months, and then since then he has been receiving therapy. I would ask the court, number 1, to of course run the sentences concurrent. Number 2, to grant time served on the drug charges, on the assault and the armed criminal action. I would ask the court to impose the minimum sentence allowed by law for a Class A felony. That is 10 years. However, the court does have the discretion, and I would, under the circumstances, I think that the SAR, this defendant, received a 6. He is not a recidivist risk. He has 1 misdemeanor conviction from a year ago, from 10 years ago, excuse me, and therefore I would ask that the court to depart significantly downward from the jury sentence. Thank you. Judge Sutherland. Mr. Parks, anything further? Mr. Parks, no, Your Honor. Judge Sutherland. Mr. Weinhaus, do you have any legal reason why a judgment of sentence should not be pronounced at this time? Mr. Weinhaus. Yes, sir, I do. Now let me make my case. Is there any way I can get my hand? You have the zapper on. That is insanity. They got a zapper on him. Is there any way I can get my hand? You have the zapper on me. You can zap me anytime you want. He can have one hand free, yes. Mr. Weinhaus, thank you, Your Honor. 13 months ago, I walked into this court, surrendered after being shot 4 times by members of the Missouri Highway Patrol. In the trial, the facts show that my actions posed absolutely no threat to or danger to whatsoever to society in general. Thus, this verdict was not in the interest of justice or to protect the public from me or my free speech. This is clearly and unequivocally a manifest injustice. A manifest injustice. I've harmed no one. The only victim in this matter has been myself. The state in their case did not prove that I harmed anybody. There was no other injured party. I was shot 4 times, twice here, once in the side of my head and once in my neck while I was on the ground. The bullet ended up in the ground. The evidence clearly shows Sergeant Folsom was lying throughout the whole trial. My attorneys, and God bless them for doing what they could, but my attorneys failed to show this court or that jury there's a gun. There's a picture of a reflection of my gun in my car. It's in the video. Shows that gun was right there on the left-hand side. That wasn't introduced into this trial. I don't understand why it wasn't introduced into this trial. Now, I don't know what's going on with these guys, but we paid them good money and it wasn't introduced in the trial. The evidence is right now on the internet. The video is out there on the internet right now. That shows that weapon was right here 2 seconds before I was shot. 1/6 of a second before I was shot, it shows Corporal Mertens walking up on me, his gun out like this. Those are freeze-frame videos which supposedly the jury wanted to see, but you wouldn't allow. Alright? So when Merton is walking up on me, he's got his gun out like this. If I'm trying to draw my weapon like they allege I was trying to do, wouldn't you think Corporal Mertens would take a different posture from the time he walked to the back of his trunk until the time he walked up on me? That wasn't showed to the court either. Could I get a glass of water, please? Please. Mr. Eastwood, I'll get him some water. We're getting you water. Mr. Weinhaus, thank you. Judge Sutherland, you can go ahead, Mr. Weinhaus. It will take a minute. Mr. Weinhaus, I can't go any further. My mouth is dry. I'm fighting for my life here. I'm about ready to, the Bible says, out of the mouth of 2 or 3 witnesses, let every word be established. How many witnesses did the state put on, other than the people that shot me? Alleged I tried to draw a weapon. 0. The only people who allege I tried to draw were the ones who shot me in cold blood, attempted to murder me on that day. That's attempted murder. I'm about ready to be an offender. I'm about ready to be an offender. Who have I offended? Has the state even failed? Has the state even introduced an offense in this matter? Allegedly trying to draw a weapon? Who did I hurt? Who was offended? If I'm going to be an offender, then there needs to be an offense. There has been no offense showed to this court. This court, if you pronounce sentence on me today and put me in jail for any more time than I have already served, this is a kangaroo court because it has done nothing to protect me from these predators. They lied to me. They came to my house to steal my printing press, in effect, by stealing my computers, because they didn't like what I was writing and printing and what I was speaking as a free speech. Obviously, you agree with that, or you wouldn't have acquitted those charges. Resisting arrest? How can you charge me with assaulting a cop when you don't charge me with resisting arrest? Another thing my attorneys failed to do, Your Honor, is in the video or in the audio interviews to the Highway Patrol, Sergeant Folsom allegedly said, "Get your hand off the gun." Folsom states, "Get your hand off the gun" at 20:31 in the video, and at the audio of the Missouri Highway Patrol before the shots were even fired. That's the first thing, that's the last thing he supposedly said to me before the shots were fired. Get your hand off the gun. Did you hear that introduced anywhere? Don't you think the jury would want to hear that? No one alleges I did anything other than the people who shot me. The picture of the gun on my left-hand side would cast reasonable doubt as to what Folsom and Mertens said my gun was on my right-hand side. There were 2 FBI agents there that day. These people took testimony of them, depositions, all right? You didn't hear anything about them saying they didn't even see a weapon on me. My defense attorneys did not even call them to testify. Mr. Parks did not call them to testify. Now you don't believe there's a reason for another trial? You let that video play. Then you acquit me on those charges, but did you instruct the jury to disregard the video when they went out? Sergeant Folsom repeatedly lied through his testimony. The jury not being able to see the freeze frame, you know what, and throughout my trial, I have no idea how many. I don't even believe they introduced any evidence on my behalf. The FBI depositions weren't introduced into evidence. Sergeant Folsom's depositions weren't introduced into evidence. None of these videos, the freeze frames, you said just a minute ago that they weren't introduced. There are freeze frame videos on the internet right now. Did you happen to see the pictures of me while I was in the emergency room? Where my wounds are? I had one come in here and go out there, go out down there. One come in here and go out down there. That can only happen if someone is standing on top of me, basically. There's a bullet in the ground. I was shot when I was laying on the ground. The evidence was not introduced. Sergeant Folsom, throughout the testimony, if you actually are interested in justice, or you know what, then you would go back and realize and understand, you would read the depositions. You would read the testimony that my gun is on the right hand, side, and then you'll go to the video on the internet and it says right there, gun reflection. You can see the picture. The holster is right here on me. It's on my right hand side. It's not on my right hand side. It's on my left hand side. Murdens is inconsistent with his testimony. Sergeant Folsom is inconsistent with his testimony. I've got video proof evidence that my gun is on my left hand side. The facts of the matter are, I was not injuring or harming anybody. I showed up there to get my computers. I was lied to. After they took my computers, they lied to me, called me up and said to come get your computers. I didn't trust them. That's why I was videotaping. I was audio taping. Did you hear their videotape or audio tape? No. You know why you didn't hear it? And I guarantee you they had it. Why would they not show up with videotape? I'm videotaping. They weren't videotaping. You know why? Because it shows a cold-blooded attempted murder. I got out of my car. I walked to the back of my car to get my computers. They said, "Why do you got a gun on?" Article 1, Section 23 of the Missouri Constitution states, and I quote, "My right to own a gun shall not be questioned. My right to carry a firearm shall not be questioned." The first thing Sergeant Folsom does is question my right to own and carry a firearm. If I'm there to do them harm, if I'm there to do them ill intent, I got a 12-gauge shotgun sitting in the back seat of that car. Now, if I was there to harm them or do anything of ill content, don't you think I would have exited the vehicle with a shotgun after I rammed their car? They were worried about me ramming their car? Well, I didn't ram their car. I got out. I'm the one videotaping. You know what, Your Honor? This is manifest injustice. I hired these people right here. These people on the internet came up with the money for them. I didn't even want a lawyer. I needed a lawyer because I thought they were going to work in my best interest. But my case was put on within half an hour. We called 3 witnesses when we could impeach Folsom and Mertens over and over and over. Now all that stuff is on the internet. The facts of the matter are very clear. I didn't harm anybody. I didn't show up to harm anybody. My intention was never to harm anybody. You know, right now, there are people in the militia, Missouri militia, who want to come and go to war with you folks over this. I've asked them not to do that, to show remarkable restraint. If you go on my website, you'll see that. But you're going to try to put me in jail for 30 to 60 years when I didn't harm anybody? You can rape a girl in this county and get 90 days. You can go around and shoot up the whole county and get 120 days. You can murder your husband and get 14 years. Is that justice? I harmed nobody. A crime as far as I'm concerned, and that's what I believe they wanted to come silence me, is because I believe a crime is an act that causes provable personal injury, loss, or harm. If there is no victim, there is no crime. No victim, no crime. Simple as that. 80% of this court's business is victimless, so-called crimes. When there is no victim, there is no crime. In my matter, I'm the victim. They are the criminals. Mr. Parks is the biggest criminal. For him to file false instruments against me, he knows the evidence that is there. He's known it for 6 months. You should know the evidence that's there if you're reading the court file. It's very clear. You can't change these facts. I didn't make up these facts. Listen to Sergeant Folsom's interview and go back and look at the depositions. Now, I'm a praying man. I got shot right here. A bullet went out the top of my head. I got shot twice right here. Once in the back of my neck. God didn't allow me to die. They tried to murder me. This whole thing comes down to what side my weapon was on. If it's on my left-hand side, you gotta quit. You got to drop these charges right now. If it's on my right side, then go ahead and throw me in jail for as long as you want. But I can prove that weapon was right here. And the reason why it would be right here is I was driving my car that day. I have my seatbelt on. I couldn't buckle my seatbelt with the weapon right there. And that's why it ended up right there. Was I stupid to wear a holstered weapon? Yeah, real stupid. But I did. But did I try to draw that holstered weapon? No, sir. And if my intention was to harm the police, if my intention was to do what they did to me, I wouldn't have exited my car with a 9mm holstered. Would have exited my car with a 12-gauge shotgun unholstered and a 22 I had in my pocket. I could have put in my pocket the 22 that would have went through a bulletproof vest. They didn't believe I was a danger that day. They weren't wearing their bulletproof vest. They lied to me to get me up there. You're sanctioning attempted murder. They tried to kill me, sir. They weren't there to play games. Within 12 seconds of me getting out of my vehicle, I'm shot on the ground. That videotape is on the internet. Now, if I go to jail for a long time over this, that's going to keep building and building and building. And that's the stuff revolutions are made of, sir. The whole thing comes down to what side my weapon is on. Reasonable doubt is achieved by the picture of the gun on my left-hand side. The sequences of pictures of Mertens as he walks back from the trunk, he walks and has his gun out like this. Excuse me? From the time he walks out of the trunk, walks from the back of his trunk until the time he walks up on me, he's like this. That's all on the internet. It's a sequence of pictures. His posture totally changes after Sergeant Folsom shoots me. He comes back up like that, like he's going to shoot then. Now, if I'm trying to draw my weapon, why isn't he in a defensive posture then? That's all there. And why these guys didn't introduce that information is beyond me. And how you can say there's not enough evidence for a new trial when I just explained to you the evidence, which is clear for all the world to see. 1/6 of a second before I was shot, Sergeant Mertens is not alarmed. That's why he's still like this. What they call high ready. The proper purpose of government in the state of Missouri, the first thing our government is supposed to do is to protect people from physical force, regardless of whether it's the police that do it or anyone else. The #1 job of our government is life. Article 1, Section 2 of the Missouri Constitution. Do we still go by the Constitution in the state of Missouri? What's up with gold fringe around? What's up with gold fringe around the flag? That is not the United States flag. The United States flag doesn't say anything about a gold fringe around on it. Read the United States Code. So the Missouri Constitution is still in effect in this country. Is that correct? If the Missouri Constitution is still in effect, then you need to go by the Constitution. Article 1, Section 2 of the Missouri Constitution says, the whole point and purpose of our government is to promote the general welfare of the people. That would be getting predators such as the Highway Patrol, the one who shot me, attempted to murder me, predators such as Bob Parks off the street, and they're the ones that need to be locked up. Promote the general welfare of the people to protect the people from predators such as Bob Parks and the Highway Patrol, and Bob Miller too. He's the biggest predator of all. He's the biggest predator too. You wouldn't let us have cameras in the courtroom. You let him come in the courtroom with a camera. All persons have the natural right to life. #1, I had a natural right to life on September 11th, sir. I got out of my car within 12 seconds. I'm on the ground bleeding from 4 holes. They didn't even call an ambulance for 7 minutes. They didn't do anything to try. They thought I was dead. Sergeant Folsom got on the phone and called his boss. He's down. It wasn't until the other highway patrolman showed up that they realized I was alive. My #1 thing was natural right to life. That day, Your Honor, they tried to take my life. They tried to murder me. Liberty, that's #2. I've been incarcerated in this jail for 390 days now. I didn't harm anybody. The state has not proved anything. That trial was a sham and you know it. That's why you allowed that video to come in. That jury was tainted, and then you didn't even tell the jury to disregard that video. Shame on you. Shame on you for not giving me another trial. Hugh came out in the paper and said you were an upright man. Jason, the probation and the parole officer, said you were an upright man. I wanted to believe that, Your Honor. I don't believe that many judges would have done what you did by dropping the charge against a judge. By dropping that charge against a judge. I want to believe that. I want to believe that there is a justice system in this country, not just us, because you see a lot of just us these days. You don't see a lot of justice. Pursuit of happiness. I haven't been able to pursue any happiness in a long time. When I sat in this jail, I spent well over $2,000 just to make phone calls. I've been isolated this whole time. I got divorced over it. I haven't been able to see my children in 14 months, sir. I have 6 children out there. I haven't seen them in 14 months. I have an 8, 10, and 12-year-old who cry every night because they don't have their father around them. I haven't been able to pay my child support. I've been able to give my ex-wife $51 since I've been in this jail. I can't go out and protect and provide for my children because Mr. Parks wants to cover up his bogus search warrant. They came to my house to steal my computers with a search warrant concerning marijuana. How is that probable cause? Mr. Parks is a predator. The man is the one who needs to be in jail. He's the one that went out and caused injury, loss, and harm. Enjoyment of the gains of my industry. I haven't been able to enjoy the gains of my industry because I was dared to come out and say, hey, our law enforcement establishment is not honoring the Constitution. It's not upholding the Constitution of the state of Missouri. We reserve the right to remove you. That's why there is a Second Amendment in this country, sir. It's not to go hunting. It's to protect people from tyranny. And what we see today in this country is judicial tyranny, black-robed terrorists who ignore the Constitution, who are playing word games. Why is my name always capitalized? Why is my name always capitalized? There's a lot to that. You look on all the court documents. Why is that? Why do I have a nom de guerre, which is a name of war? There's something more going on here than meets the eye here. And I was trying to point that out to the people. And they were so afraid of it, they tried to kill me. I was running for the office of coroner in Crawford County. Why was I running for coroner? Because there's 2 murders down there committed by law enforcement. I was looking into that. That's why they tried to murder me. The office of the coroner, which this county doesn't have a coroner anymore, but the coroner can investigate murder in a panel a grand jury. Every day the court preys on the fatherless, the poor, the fatherless, the poor, the widow, the weak. I stood up against the tyranny for 16 years, and then on September the 11th, they tried to murder me for my political views. That all persons are equal and entitled to equal rights under the law. Assault on a law enforcement officer, and that's more valuable than regular assault, is that equal rights? That's what's on the front of the Supreme Court in Washington, D.C., equal rights under the law. The police are more important than me. Was Henry Folsom charged with attempted murder, first-degree assault on myself? Is he facing 30 to 60 years? No, but the Highway Patrol fired him. And why is that? Why was he relieved? This is the second time he tried to kill somebody. He already did it once and they still paid the man. He already did it once and they still paid the man. This is the second time, maybe 2 strikes he's gone, but he got fired over this. They tried to kill me, sir, and if you allow this to go down, if you allow a sentence to be pronounced upon me in any way, you're just as guilty. To give security to these things, equal rights and opportunity under the law, the general welfare of the people, taking predators off the street like Bob Parks, taking predators off the street like the highway patrolman who went out and callously shot at me, tried to kill me that day. That's the general welfare of the people being supreme. I believe the governor of the state of Missouri is the one who ordered this entire investigation. I believe that's what Mr. Parks said in open court. I believe that's what Mr. Parks said in open court. Why would the governor of the state of Missouri want to be concerned about eliminating me? He's familiar with me. We grew up in the same county. I've been doing my paper in Jefferson County for 16 years. He's well aware of who I am. To give security to these things is the principal office of government. Equal rights, life, liberty, the pursuit of happiness, equal rights under the law, to protect people from physical force. First and foremost, the only job of our government is to protect our people from physical force first and foremost. It has failed to protect me. Our government has failed its chief design. When the only victim stolen from, I'm the only victim in this matter, Your Honor. If the state can put another person up on the stand to say that I've victimized them, they failed to do so. I'm the only victim. The only one who suffered injury, loss, or harm is myself. I was lied to, stolen from, first of all. The free press, the right of the free press. The only business specifically protected by the United States Constitution is a free press. And they came and stole my computers. They lied to me and said, hey, come get your computers. When I got there, they tried to kill me. Now they want to lock me up for the rest of my life, and I've harmed nobody? This is not America. If you allow that to happen, this is not America. This is not why thousands and millions of people have died on the battlefields to protect. The Gettysburg Address was delivered 150 years ago. Government of the people, for the people, and by the people shall never perish from the face of the earth. It's just about perished if you allow this to happen. There is no evidence whatsoever to sustain a conviction. That's a legal reason. That's a legal reason for you to overturn this conviction right now. And maybe my lawyers couldn't convey that strongly enough to you because they're going to be able to go home tonight. Should you not act and do the right thing here, I'm going to have to go back to a jail cell and make phone calls for 50 cents a minute, and I have no money to call anybody. I'm going to have to go to prison, go to No More Victims Lane, when there is no victim in this matter. I'm the only victim, Your Honor. I'm the only victim. Our government has failed its chief design. Should you not do your responsible thing today? You took an oath to uphold the Constitution, I would assume, or you should have. I would appreciate if you honor that oath. Therefore, there is no evidence to sustain a conviction, none whatsoever. The only evidence you had to sustain a conviction was the testimony of Henry Folsom, and I've just demonstrated beyond a reasonable doubt that my weapon was right there on my left-hand side. If you're interested in justice, maybe we can review the tapes. Maybe you can freeze frame it. Maybe my lawyers can introduce that into evidence. Maybe they'll want to introduce the fact that Henry Folsom said, hey, get your hand off the gun. Did you hear that? I didn't hear that. It's not on any of the tapes. He said, hey, I've got papers for you to sign for your computers. That's not on any of the tapes. Henry Folsom, as a matter of fact, said, Jeff, I got your computers right here. Jeff, I got your papers right here. Get your hand off the gun. And then 20 minutes later, in his interview with the Highway Patrol, the question is asked to him, how long did it take until you pulled into the parking lot until shots were fired? 12 to 15 seconds, just long enough to say, what are you doing with that gun? That's your star witness. 3 things right there he was impeached on. 2 of the 3 things my lawyers didn't even bring up to you. Now, I don't know what the definition of ineffective assistance of counsel is, but I believe that is right there. Now, I don't know why they want to play assistant prosecutor, but at the Erwin Rommel School of Law, we're talking the battlefield is the courtroom. The judge and the enemy, the judge and the PA are your enemy, and your lawyer is the enemy's spy. And in this matter, that's exactly what's happened here. The evidence, the facts of the matter dictate a judgment of acquittal today. And I'd like to be able to walk out of this and go back to my life. I'd be able to go hug. I'd be able to go hug my children this evening. That I'd be able to provide for my family. That's what justice dictates today, not just us. You have no obligation to protect this wicked system, and it is wicked, Your Honor. You as a man can stand up against this tyranny and say, let him go. Justice demands that the convictions be sustained. The convictions be overturned. There is no evidence to sustain a conviction, and I be set free. So I've said my piece, and I appreciate you letting me say it, but justice demands that I be set free today. There is no evidence whatsoever to say that I tried to draw a weapon on them. I don't care what Mr. Parks alleges because he had nothing to sustain a conviction. He had 2 witnesses, and I both proved that they've impeached themselves throughout their testimony. So, Your Honor, I ask you to do the right thing and set me free in Jesus' name. Amen. Judge Sutherland, the motion for new trial is denied. I will point out a very important fact here, and that is that the jury is the decider of facts. All right, I'm going to pause here on page 43, and we'll pick this up later. All right, let's continue with page 43 and try to get to the end. Mr. Weinhaus, the jury is only good enough to act on the information that was provided, and you, Judge Sutherland, that's what I have to act on as well. Mr. Weinhaus, you know what, Your Honor? You're a fraud. If you allow this conviction to stand, you are a fraud, sir, and you will be judged. Judge not lest you be judged, and if you don't set me free, then you're just as bad as they are. You're an attempted murderer. Judge Sutherland, no one having shown any legal reason why the judgment of sentence... Mr. Weinhaus, I believe I did show legal reason. Judge Sutherland, should not be pronounced. It is the judgment and sentence of the court on count 1. That's the felony possession of a controlled substance, that the defendant serve a term of 2 years in the Missouri Department of Corrections. On count 3, that's the misdemeanor possession of a controlled substance charge. The defendant serve a term of 1 year in the Franklin County Jail. On the count, I believe it's count 4, the charge of attempted assault of a law enforcement officer in the first degree, that the defendant serve a term of 30 years in the Missouri Department of Corrections. And on count 5, the armed criminal action charge, the defendant also serve a term of 30 years in the Missouri Department of Corrections. Wow. I will point out that those were the recommendations that the jury made after the sentencing hearing, and it is my practice not to override or undercut either way the jury's recommendation as to the sentence. However, it is the judgment of the order of the court that those 4 sentences be served concurrently. It would be the intention of the court that the defendant serve a total of 30 years in the Missouri Department of Corrections. Mr. Weinhaus, for what? For what? Judge Sutherland, credited with all time served awaiting disposition. There will be a crime victims compensation final judgment in the amount of, what is it, $68? $68, which is directed to be entered. Mr. Weinhaus, there's 2 things that can happen at this point. I suspect both will. First of all, you do have the right to appeal the conviction to the Missouri Court of Appeals, Eastern District in St. Louis. That needs to proceed first. Mr. Eastwood, are you going to file a motion, or excuse me, a notice of appeal? Mr. Eastwood, yes sir, I'm going to timely file a notice of appeal with this court. Judge Sutherland, notice of appeal has come to be filed within 10 days, and then you have time to get transcripts made and all that sort of thing. Normally the trial attorney is not hired for trial and appeal. You can of course hire Mr. Eastwood for the appeal of another attorney for the appeal. If you are indigent, you may apply for the public defender as well, if you wish to file an application for public defender services. Mr. Weinhaus, I believe the court has one on file already. Judge Sutherland, that's some months old. They usually, Mr. Weinhaus, it's current. I haven't been able to do anything for the last 8 months. I've been in jail locked up, and you know what? Judge Sutherland, I understand that. Mr. Weinhaus, you know what? You're a fraud. Judge Sutherland, I would recommend you file a new application for public defender services. Do you have those at the sheriff's office? Mr. Weinhaus, 30 years for what? Mr. Parks, I believe it would be filed in the Department of Corrections for the appeal attorney, because it wouldn't be the local attorneys that would represent him on the appeal. Judge Sutherland, well, at any rate, you need to get that filed. Mr. Weinhaus, I want to know why you wouldn't give me another trial. Judge Sutherland, Mr. Weinhaus, I'm not going to debate that with you. Mr. Weinhaus, the debate is over, buddy. You're doomed. Judge Sutherland, at any rate, the appeal has to proceed first. I can't put a time limit on that. Could be looking at 6 months, 8 months, 10 months, even up to a year before the appeal gets decided. That's not up to me. Once the appeal is ruled on, the Court of Appeals, of course, can do one of 2 things. They can confirm the conviction, or they can reverse all the convictions, or somewhere in between. Affirm some, reverse some. That's going to be up to them. But in the event that one or more of these convictions is affirmed, after that you have the right to proceed with your post-conviction rights under Rule 29.15, and that's what I need to inform you about now. I don't know if you've been informed of this or not, but I need to go over it in any event. You have the right to file the post-conviction motion in your court to vacate, set aside, or correct your conviction or the sentence. In this case, if you claim first that your conviction or the sentence imposed violates the Constitution of the United States. Mr. Weinhaus, which it does, and you're aware of that, sir. Judge Sutherland, or the Constitution or the laws of the state of Missouri, or 2, that this court was without jurisdiction. Mr. Weinhaus, I believe it is. That's not the American flag. My name is not all capitalized. Judge Sutherland, Mr. Weinhaus. Mr. Weinhaus, you know what? You need to do your job, Your Honor. Judge Sutherland, you have had your opportunity to speak. I am doing my job, and it's my turn to speak. Mr. Weinhaus, no, you're not. You're a fraud. You're a fraud. Judge Sutherland, number 3, the third grounds is if the sentence imposed is in excess of the maximum sentence authorized by law. Mr. Weinhaus, you're a fraud. Judge Sutherland, or 4, that you received ineffective assistance of counsel, which you already referred to. A post-conviction motion is an exclusive procedure by which you can seek relief for those 4 types of claims. The forms will be provided for you at the Department of Corrections upon your request. No cost deposit filing fees are necessary in order to file that motion. What normally happens if you file the post-conviction rights, since the case is assigned to me, it would come to me. I would appoint appellate counsel out of Columbia to represent you on those post-conviction rights, and they would have an opportunity to file an amended motion. Mr. Weinhaus, let me ask you this. Post-conviction, we're at post-conviction right now. Why won't you do the right thing? The evidence is very clear, Your Honor. Judge Sutherland, Mr. Weinhaus, the evidence is not very clear because most of the things you were talking about, there was no evidence of at trial. What I'm trying to explain to you is the timing of filing the post-conviction. Mr. Weinhaus, I can read, Your Honor, and I appreciate that, but you need to do your job and set me free now. Judge Sutherland, Mr. Weinhaus, I've harmed nobody. Judge Sutherland, if the convictions are appealed, the Court of Appeals will issue a written opinion affirming them. About 30 days thereafter, they will issue what's called a mandate, a single sheet of paper basically affirming that they affirm the convictions. From the date the mandate is issued, you have 90 days within which to file the post-conviction motion. If you're 91 days, you're out of luck. So you've got to file that within 90 days, and that's important. And that's the important thing I want to explain to you today. If you don't file it within 90 days after the Court of Appeals mandate is issued, you will have completely waived your post-conviction rights. If you do file that motion, you must include every ground to you for vacating, setting aside, or correcting the judgment or sentence. If you're indigent and file your own motion, a lawyer will be appointed for you. Your lawyer would then have 60 days to file an amended motion. A written request for a hearing must be made within the time limits, because if no request for a hearing is timely made, nor hearing will be held. Do you understand what I've just told you? Mr. Weinhaus, no. Mr. Weinhaus, no, please do it again. Judge Sutherland, the whole thing again or examples? Mr. Weinhaus, yes, sir. Judge Sutherland, you have the right to file a post-conviction motion under Rule 2915 in this court to vacate, set aside, or correct your conviction or the sentence. In this case, if you claim that your conviction or the sentence imposed violates the Constitution of the United States or the Constitution or laws of the state of Missouri. Mr. Weinhaus, all right. Judge Sutherland, or that this court was without jurisdiction to impose the sentence or the sentence imposed is in excess of the maximum sentence authorized by law, or that you received ineffective assistance of counsel. Mr. Weinhaus, I have, and all those things have been noticed to the court, and the court is refusing to act on that. What is your legal reason? Judge Sutherland, Mr. Weinhaus, answer my question. Quit playing the game. This is a charade. Judge Sutherland, Mr. Weinhaus, I am going to have you send you out and do this on Polycom or have you gagged. Mr. Weinhaus, whatever you think is necessary. I just want some justice today, Your Honor, and the fact of the matter is I've harmed nobody and you know it. Judge Sutherland, Mr. Weinhaus, you made your statement. It's my turn, okay? I do want to ask about the assistance of counsel that you received. You made some comments about your representation. Mr. Weinhaus, I'd love to talk about my counsel. Judge Sutherland, is there any other comments you want to make about your representation of counsel? Mr. Weinhaus, yes, sir, I've got a whole thing here. First of all, these folks were hired to defend me. They were paid. I don't know how much money they were paid, 6, 8, 10,000. I don't know. I didn't raise the money. It was all raised on the internet because there are people out there who love this country and believe in this country. But my first question is, how many exhibits did you put in there, Hugh? How many exhibits did you enter on my behalf? Judge Sutherland, Mr. Eastwood is not a witness at this point. Mr. Weinhaus, okay, the point being I don't remember any. He didn't put on a defense. He called 3 witnesses, and by the way, all 3 of the witnesses saw my hands empty as I fell to the ground after being shot at 6 times, hit 4 but those people are still on the street today. As a matter of fact, they all got their cheerleaders right there with them. Judge Sutherland, Mr. Weinhaus, you're getting off the subject. Mr. Weinhaus, I've got 30 years here, Your Honor. Judge Sutherland, I understand that. I'm interested in your comments you have to make about your representation. Mr. Weinhaus, they failed to introduce pictures of me in the hospital. Highway Patrol was there taking pictures. As soon as I got to the ER, showed a hole right there in my head, 2 holes in my head. Didn't show that to the jury. Mr. Parks even said, hey, he looks fine to me. My lawyers didn't say anything about that. Throughout the course of the trial, Folsom basically impeached himself. Folsom basically wrote a novel of what happened in less than 12 seconds. Folsom claims in the audio interviews of the event conducted by the Highway Patrol, he stated to the victim, I got your computers right here. Jeff, I got papers for you to sign right here. They brought that up to Mr. Folsom, but they failed to bring up the fact that he said, Jeff, get your hand off the gun. That's not anywhere in this trial, but it's there on the tape. If you care to listen to the tape, if you're concerned about justice, or is it just us? And then later on the interview, Folsom was asked Jeff, how long was it until Jeff got out of his car until the time he was shot? 12 to 15 seconds, just long enough to say what you are doing with that gun. That wasn't brought up in my trial. There's a reflection of me in the car. By the grace of God, it ended up, I got a copy of 1/30th of a second. Shows that the gun right there. I asked him at the trial to introduce that, put that in there. They refused to. They were more concerned about meeting your deadline to be done with my case by 11 o'clock that day than they were about serving me justice. Judge Sutherland. Mr. Weinhaus, I will say right now, there was no deadline. Mr. Weinhaus, you know what? You had an agenda throughout the whole thing. You're the fixer. You came from Missouri Supreme Court. You're a fraud, simple as that. And tonight you won't be able to sleep unless you're heavily medicated or drunk. The FBI was not called. The FBI testified in their depositions. They didn't even see a weapon on me. I told them to call the FBI. They didn't call the FBI. Depositions, we paid for depositions, or maybe the court is paying for it. How does the court cost work? We paid for the depositions. They didn't introduce them. They didn't put them before the jury. Judge Sutherland, normally depositions are not admissible. Mr. Weinhaus, well, they should have been. They both said, hey, we've got papers for you to sign. That wasn't brought up. Mertens wasn't brought up. The reason for the probable cause, Mr. Mertens didn't even smell marijuana that day. Folsom is the only one that smelled marijuana. That wasn't brought up. The bullet where Mr. Folsom said, hey, I think I shot at the gutter guys. They didn't bring that up. There's a hole in the wall of the gas station. That wasn't brought up. There is a picture, Judge Sutherland. Actually, I believe it was. Mr. Weinhaus, did you see the picture? No, picture tells the story. How about the picture of the bullet in the ground? How does a bullet get in the ground unless you're on the ground when they fire the gun? They shot me when I'm laying on the ground. Are you proud of them? You allowed that. You're just as bad as they are. I mean, my goodness gracious. The still shot of Mr. Mertens, there's a sequence of pictures. There's a sequence of pictures, about 8 or 10 pictures. Judge Sutherland. Mr. Weinhaus, I'm sorry for interrupting you, but you covered all this before. Mr. Weinhaus, well, it needs to be covered again because you haven't it needs to be covered again because you haven't changed your mind. I'm giving you an opportunity to do the right thing. Here, Your Honor, Judge Sutherland. I'm not going to change my mind at this point, Mr. Weinhaus. Let me ask you another question. Were there any witnesses you asked your attorney to interview that they didn't interview or take depositions of? Mr. Weinhaus, I wasn't aware of any more witnesses other than the ones I said, the FBI. They were called to the stand, the 3 witnesses. I don't know about all the people who were in the gas station. Why was the troopers who showed up on the scene first? Why were they not interviewed? Why was the dash cam not introduced? Hey, whose side are you on? The still shots, Judge Sutherland. You had copies and an opportunity to review the police reports, is that right? Mr. Weinhaus, yes, sir. Obviously, I reviewed the police reports. Have you reviewed the police? Have you reviewed the police reports? Judge Sutherland, Mr. Weinhaus, I'm not on the stand either. Mr. Weinhaus, indulge me. You just gave me 30 years and I didn't hurt anybody? I didn't harm anybody? You gave me 30 years and I haven't harmed anybody? Nobody? I'm the one who's been harmed. I'm the victim. That makes you the criminal. And you'll be able to sleep tonight, huh? Go home to your family, hug your grandkids, huh? You're the criminal. You're the one who's caused injury, loss, or harm. You're a black-robed terrorist, an enemy combatant, no different than Osama bin Laden. Oh, you think it's funny. Judge Sutherland. I do. It is rather amusing. Mr. Weinhaus, really? You think that's funny? My lawyers didn't have the jury instructed to ask you to instruct the jury to disregard the video, did he? Why wouldn't you instruct the jury to disregard that video? Judge Sutherland, once again, these are all things you covered already. It's on the record. Mr. Weinhaus, and it's going to go on the record again. You asked me if I had a reason for ineffective assistance of counsel. I'm trying to give you those reasons. Now, will you allow me to do that? I'm already going away for 30 years. Judge Sutherland, you done it once. Mr. Weinhaus, I didn't hurt anybody or rape anybody. I didn't get 90 days. I didn't kill anybody and get 14 years. I didn't go around and shoot up the county and get 120 days. I didn't have a drug deal go bad and shoot up people and get probation. The jury was not instructed to say, hey, if he doesn't testify, then don't hold that against him. Did you tell the jury that? No. My lawyers didn't call up Jim Byrne. Jim Byrne is a computer expert who spent hours researching this case. He's the one that showed my hands were in the air when they shot me, that I was going down on the ground when they shot me. Okay? None of that was They didn't bring up any of that. He wasn't interviewed. He wasn't called as a witness. Jim Byrne is the one that said, hey, he didn't say you're going to have to shoot me, man. He said you don't have to shoot me, man. Now, would that make a difference to the jury if I said you don't have to shoot me and I'm going down on the ground and my hands are in the air? I'm surrendering. Do you think that would make a difference? I do. No picture was shown of the bullet in the ground introduced. How about the communication officer talking to Dave Bauer of the Highway Patrol? The CD, audio CD that said Dave Bauer was asked on the phone. What's going on? Oh, Weinhaus, they're messing with Weinhaus. And Bauer comes back and says, oh, they're messing with Weinhaus again. And then communications officer Smith says, hey, maybe he learned his lesson this time. That wasn't introduced. That's all on there. Did not show the entire watch video. Did not call my ex-wife Valerie to testify, hey, he called us up. They didn't even play that video. That video wasn't even introduced. That video wasn't even introduced that I called my ex-wife and said, hey, you need to record this. I don't trust the Highway Patrol. They said they're going to give me back my computers. Didn't play that. Didn't play the entire watch video. There's 23 minutes on that watch video. The first 5 minutes is me going down there praying and God being gracious enough to answer my prayer and not letting me die that day. After they tried to murder me. After you tried to murder me because you just as guilty now, and woe unto you. When the road officer pulled in, they didn't show the dash cam of the road officer pulling in and Folsom and Merton standing there, get away, get away, get away. They tried to kill me that day, Your Honor. The still shots were not introduced into evidence. How could he not introduce those still shots into evidence? They vindicate me. Ain't nothing changed, but you're just as bad as he is because you won't come off your bench there and do the right thing and set an innocent man free. Woe unto them that call evil good and good evil, that put light for darkness and bitter for sweet. Woe unto them that are wise in their own eyes and prudent in their own ways. I mean, how can you even look at me? By his own admission, Folsom admitted that he tried to shoot at the people who were there with the gutters. That wasn't introduced. He tried to kill other people who were there. There was no videotapes of the depositions. My counsel and I, like you, I don't know why he sold me out or didn't adequately defend me. Judge Sutherland. Mr. Weinhaus, at this point I'm going to interrupt you. Pardon me. I have seen and heard nothing that indicates any such thing. As a matter of fact, I think Mr. Eastwood did an exceptionally good job. Mr. Weinhaus, really? That's why I got 30 years. Judge Sutherland, you started with 8 counts. 2 of them got dismissed after the state's evidence. 2 more you were found not guilty of, and I was impressed with Mr. Eastwood's representation of you throughout the trial. Let's put it that way. Mr. Weinhaus, really? If you're so impressed, then do the right thing and acquit me after you've been made aware of the facts. If you don't acquit me right now, you don't unloose my hands and let me go home to my children and my family, you're just as guilty as they are. You're just as guilty as Folsom is. You're just as guilty as Mertens is. You're just as guilty as Bob Parks is. You are a black-robed terrorist, and that's the reason why I put my paper out and do videos is to get people like you off the bench, because I don't believe you did a good job at all here. You're perverting justice. The court is a kangaroo court. I walked into this court as the victim. I'm walking out of it as a victim, and you're well aware of the facts of the matter. And the fact of the matter is very simple. I'm the one who was shot at. I'm the victim here. That would make you the criminal. It would make these highway patrolmen the criminal. And I just pray that the American people wake up and realize what's going on in this country, because we've been overthrown by black-robed terrorists such as yourself. And shame on you for not doing the right thing. And God is my witness, will deal with you. Vengeance is his, saith the Lord. He will repay. I'm not going to threaten you to do anything. I'm not going to threaten you to do anything. That's not who I am. Psalms 94 is very clear. O Lord God, through vengeance belongeth, show yourself, and he will show himself in your life. You have come against a child of the Most High God. I was shot 4 times. I should be dead. He allowed me to live to tell you. Judge Sutherland. Mr. Weinhaus, that you need to repent and get right with the Lord. Judge Sutherland, Mr. Weinhaus, that's enough. We are done. The court finds that there's no probable cause to believe the defendant has received ineffective assistance of counsel. Mr. Weinhaus, oh, come on. Judge Sutherland, the defendant is remanded into the custody of the sheriff. We're in recess. Hearing adjourned. State of Missouri, County of Franklin, I, Kim Rockledge, duly commissioned, qualified, and authorized to administer oaths and to certify to depositions, do hereby certify that pursuant to agreement in the civil cause now pending and undetermined in the Circuit Court of Franklin County, State of Missouri, to be used in the trial of said Cause in said court I was attended at the Franklin County Justice Center, 401 East Main Street, Union, in the county of Franklin, state of Missouri, on the 25th day of November 2013. Said hearing was reported by me in shorthand and caused to be transcribed into writing, and the foregoing pages correctly set forth the testimony together with the questions propounded by counsel and remarks and objections of counsel thereto, and is in all respects a full, true, correct, and complete transcript. I further certify that I am not of counsel or attorney for either of the parties to said suit, not related to nor interested in any of the parties or their attorneys. Kim Rockledge. My, that was one heck of a day in trial. I pray that the Lord acts quickly and frees Jeffrey Weinhaus and holds Folsom and Mertens and this judge accountable for the wickedness that they've done, as well as the prosecutor Parks and even the defense attorney who sold him out. I pray all of those evil bastards get held accountable for the wickedness that they've done to Jeffrey Weinhaus.